Canon 6 Accountability, Part 1, Section 1 to 20, Code of Professional Responsibility and Accountability. Canon 6 Accountability. By taking the lawyer's oath, a lawyer becomes a guardian of the law and an administrator of justice. As such, the lawyer shall observe the highest degree of morality, adhere to rigid standards of mental fitness, and faithfully comply with the rules of the legal profession. Failure to honor this covenant makes the lawyer unfit to continue in the practice of law and accountable to society, the courts, the legal profession, and the client. Section 1. Nature of disciplinary proceedings against lawyers. Disciplinary proceedings against lawyers shall be confidential in character and summary in nature. Nonetheless, the final order of the Supreme Court shall be published like its decisions in other cases. Section 2. How instituted. Proceedings from the disbarment, suspension, or discipline of lawyers may be commenced by the Supreme Court on its own initiative or upon the filing of a verified complaint by the Board of Governors of the Integrated Bar of the Philippines, IBP, or by any person before the Supreme Court or the IBP. However, a verified complaint against a government lawyer which seeks to discipline such lawyer as a member of the bar shall only be filed in the Supreme Court. A verified complaint filed with the Supreme Court may be referred to the IBP for investigation, report, and recommendation, except when filed directly by the IBP, in which case the verified complaint shall be referred to the Office of the Bar Confidant or such fact-finding body as may be designated. Complaints for disbarment, suspension, and discipline filed against incumbent justices of the Court of Appeals, Sandigan Bayan, Court of Tax Appeals, and judges of lower courts, or against lawyers in the judicial service, whether they are charged singly or jointly with other respondents, and whether such complaint deals with acts unrelated to the discharge of their official functions, shall be forwarded by the IBP to the Supreme Court for appropriate disposition under Rule 140 as amended. Section 3. Contents of the complaint. The complaint shall be verified. It shall state clearly and concisely the acts or omissions complained of, and shall be supported by judicial affidavits of the witnesses and such other documents in support thereof. If the verified complaint is filed before the IBP, 6 copies thereof shall be filed with the Secretary of the IBP or the Secretary of any of its chapters, who shall forthwith transmit the same to the IBP Board of Governors. Section 4. List of Investigating Commissioners. Qualifications. The IBP shall recommend to the Supreme Court 150 lawyers in good standing and repute, whom the IBP shall proportionately select from its 9 regions. The IBP may periodically recommend the adjustment of the number of investigating commissioners to the Supreme Court according to the existing caseload. The list, with the curriculum vitae of the recommended lawyers, shall be submitted by the IBP within a month from the effectivity of the code. Only those approved by the Supreme Court may be designated as investigating commissioners, who shall serve for a term of 3 years unless sooner removed, replaced, or resigned. An updated list shall be submitted by the IBP to the Supreme Court upon removal, replacement, or resignation of a lawyer previously designated as investigating commissioner by the Supreme Court. All approved investigating commissioners shall take an oath of office in the form prescribed by the IBP. A copy of the investigating commissioner's appointment and oath shall be transmitted to the Supreme Court. Section 5. Assignment by raffle of investigating commissioner. The IBP Board of Governors shall assign by raffle an investigating commissioner from among the lawyers approved by the Supreme Court in the list submitted by the IBP, or when special circumstances so warrant, a panel of 3 investigating commissioners to investigate the complaint. Section 6. Complaint against a government lawyer. When a complaint is filed against a government lawyer, the investigating commissioner shall determine within 5 days from assignment by raffle whether the concerned agency, the ombudsman, or the Supreme Court has jurisdiction. If the allegations in the complaint touch upon the lawyer's continuing obligations under the CPRA, or if the allegations, assuming them to be true, make the lawyer unfit to practice the profession, then the investigating commissioner shall proceed with the case. Otherwise, the investigating commissioner shall recommend that the complaint be dismissed. Section 7. Disqualification of investigating commissioner. An investigating commissioner shall, on his or her own initiative or upon motion, recuse from acting as such on the grounds of relationship within the 4th degree of consanguinity or affinity with any of the parties or their counsel, professional legal relationship, pecuniary interest, or where he or she has acted as counsel for either party, unless in the last instance the parties sign and enter upon the record their written consent. Where an investigating commissioner does not disqualify himself or herself, a party may file the appropriate motion for disqualification before the IBP Board of Governors. The IBP Board of Governors shall resolve the motion within 5 days from receipt thereof. Upon vote of majority of the members present, there being a quorum, the IBP Board of Governors shall order the disqualification and designate a replace of the disqualified investigating commissioner. The decision of the IBP Board of Governors on the disqualification shall be final. Section 8. Duties of the investigating commissioner. The investigating commissioner shall investigate a complaint against any members of the integrated bar and thereafter submit a report embodying the recommended action to the IBP Board of Governors within a total period not exceeding 180 calendar days from assignment by raffle. Section 9. Submissions allowed. Verification. The only submissions allowed are the complaint, answer, and position papers, all of which shall be verified. A certificate of non-forum shopping shall accompany the verified complaint. An unverified complaint shall be recommended for outright dismissal. An unverified answer or position paper shall not be considered. Section 10. Prohibited submissions. The following submissions are prohibited. A. Motion to dismiss the complaint or petition, except on the ground of lack of jurisdiction, litis pendentia, or res judicata. B. Motion for a bill of particulars. C. Motion to reopen or for new trial. D. Petition for relief from judgment. E. Supplemental pleadings. F. Motion for reconsideration of a judgment on the merits, except a motion for reconsideration of an interlocutory order or resolution. Section 11. Lack of prima facie showing of liability, outright dismissal. Within 15 calendar days from the assignment by raffle, if the investigating commissioner finds no prima facie showing of liability, the investigating commissioner shall recommend the outright dismissal of the complaint to the Supreme Court. The Supreme Court may adopt the recommendation and dismiss the complaint outright. Otherwise, the Supreme Court shall direct the investigating commissioner to conduct further proceedings. Section 12. Effect of death of lawyer on administrative disciplinary cases. Disciplinary proceedings may not be instituted against a lawyer who has died. If such proceedings have been instituted notwithstanding the lawyer's death, the administrative case against said lawyer shall be dismissed. The death of the lawyer during the pendency of the case shall cause its dismissal. Section 13. Issuance of summons. Within 15 calendar days from assignment by raffle, the investigating commissioner shall issue the required summons, attaching thereto a copy of the verified complaint and supporting documents, if any. The summons shall require the respondent to file a verified answer. Section 14. Verified answer. The answer shall be verified and filed within 30 calendar days from receipt of the summons. The verified answer shall be accompanied by judicial affidavits of the witnesses and such other documents in support thereof. The respondent may, upon motion for good cause, be given one extension of 15 calendar days to file the verified answer. 2 copies of the verified answer shall be filed with the investigating commissioner with proof of service on the complainant or the latter's counsel. Section 15. Dismissal after answer. If the investigating commissioner finds that the complaint is not meritorious based on the verified answer, the investigating commissioner shall recommend to the Supreme Court the dismissal of the complaint. Otherwise, the Supreme Court shall direct the investigating commissioner to conduct further proceedings. Section 16. Irrelevance of desistance, settlement, compromise, restitution, withdrawal, or failure to prosecute. No investigation shall be interrupted or terminated by reason of the desistance, settlement, compromise, restitution, withdrawal of the charges, or failure of the complainant to prosecute the same. Section 17. Counsel de Officio. The IBP Board of Governors shall appoint a suitable member of the integrated bar as counsel de officio to assist the complainant or the respondent during the investigation in case of need for such assistance. Section 18. Investigation. Upon joinder of issues or upon failure of the respondent to answer, the investigating commissioner shall proceed with the investigation of the case. However, if despite reasonable notice, the respondent fails to file an answer or appear, the investigation shall proceed ex parte. In both instances, the investigation shall proceed with dispatched. The respondent shall be given full opportunity to defend and be heard, whether through counsel or not, and to present witnesses. The investigating commissioner shall have the power to issue subpoena and administer oaths and affirmations in relation to the conduct of the proceedings. Section 19. Indirect contempt. Willful failure or refusal to obey a subpoena or any other lawful order issued by the investigating commissioner shall be dealt with as indirect contempt of court. The investigating commissioner shall require the alleged contemptor to show cause within 10 calendar days from notice. Upon receipt of the compliance or lapse of the period to comply, the investigating commissioner may conduct a hearing, if necessary, in accordance with the procedures set forth under Canon 6, Section 20, for hearings before the investigating commissioner. Such hearing shall be terminated within 15 calendar days from commencement. Thereafter, the investigating commissioner shall submit a report and recommendation to the IBP Board of Governors within a period of 15 calendar days from termination of the contempt hearing. Within 30 calendar days from receipt of the investigating commissioner's report and recommendation on the contempt charge, the IBP Board of Governors, through a resolution, may either adopt, modify, or disapprove the recommendation of the investigating commissioner. The action of the IBP Board of Governors shall be immediately executory. The action of the IBP Board of Governors may be appealed to the Supreme Court. The execution of the order of contempt shall not be suspended unless a bond is filed by the person adjudged in contempt in an amount fixed by the IBP Board of Governors, conditioned upon compliance with and performance of the final action in the contempt case if decided against the contemnor. Section 20. Submission of preliminary conference briefs. Immediately upon receipt of the verified answer, the investigating commissioner shall send a notice to the parties and counsels to simultaneously file within a non-extendable period of 10 calendar days from receipt of the notice the respective preliminary conference briefs, which shall contain the following: A. Admissions. B. Stipulation of facts. C. Definition of issues. D. Judicial affidavits and marked exhibits accompanied by the lawyer's certification that the attached documents are the genuine or faithful reproductions of the original in his or her custody or possession. E. Such other matters as may aid in the prompt disposition of the action. That's it, Canon 6, Accountability, Part 1, Sections 1 to 20 of the Code of Professional Responsibility and Accountability. If you find this video helpful and informative, please do like, share, and subscribe. Thank you very much.